Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. As always, my name is Jenna Labor, and I'm your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions, interact with our speaker. If you have a question, please put it in the comments section below, and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button, let your friends know, and click the alerts icon so that you make sure you don't miss an episode. Today, we have Blake Johnson with us out of Utah to talk about the Trial College. Blake practices personal injury in Utah at his own firm with a couple of partners, in addition to being KTI faculty. And he's the dean of the Trial College. As always, we will put his contact information in the description below so you can contact him directly with any questions you have about this college or about anything Edge. Blake, tell us about the Trial College and what we can expect when we attend.
Perfect. Thank you, Jenna. Happy to be here and I appreciate the opportunity. The Trial College, I've been the co-dean of the Trial College for, I want to say, almost 4 years now at this point. And so I think it's a great opportunity to kind of check in and remind people what the Trial College is and what it can do for them. So to start right out of the gate, I also wanted to address some of the things about the Trial College as we hear some feedback, because obviously at the end of every course we get feedback and want to hear what people think and how it went for them. So one of the things that we hear often, or at least we see, is that they didn't get out of it what they were hoping to get. And so I want to address that. I want to swift boat that right out of the gate. What you can expect with the Trial College is not a template. And that is, that's what I see. I think a lot of people want a template. We go to law school, we don't learn anything about how to actually do a trial. And so you're put out into practice, and whether it's through experience or whatever, you're going to learn, obviously, the nuts and bolts of how to introduce an exhibit, things like that, things that they don't really teach in law school. But the other thing that they completely ignore in law school is trial strategy, and there's not many places you can get that. So that is what the KTI Trial College is all about. It's about helping people and giving them the tools so that they can take those back to their personal cases, their own cases, and put together a trial that's cohesive and is going to be persuasive. So that is kind of my, I guess, disclaimer, I would say, is don't come to the Trial College expecting that we're going to tell you, here's how you structure it. This is what you say right here, and then you go right here and move on into that. It is a very different college in the sense that what we're trying to embed and get into the students is the tools, so that they can take these tools back and apply them to their own cases, because every case is different and every case strategy is going to be different. So it's not so much focused on a template approach. It's more so, here's the tools, here's why this is powerful. And it's going very deep on those concepts, because if you don't have a true understanding of the concepts that we're teaching in the Trial College, you're never going to be able to apply them to your own case. So that's what I wanted to say from the outset.
I agree with that. I think I felt like in classes the past that I've taught, that's one of the first things, right? We open with, what do you expect to get? What do you want? And people are like, well, I want to know when to do this witness or when to do that exhibit or that sort of thing. And that's really not what the Trial College is about. It's a lot more philosophical. And I don't know, Blake, what do you think about when people should take that course? When should people take trial in the lineup?
That also is a tough question, because I'll tell you right now, if you do not have a strong background and haven't taken a lot of the courses, you're going to get in there and there's going to be a lot of new information you're not going to know what to do with. And I'll tell you, the faculty, and Jenna, you're faculty for the Trial College as well. We've gone back and forth on that, because it does create, some problems if you have someone who's not up to speed on the KTI concepts. But on the flip side, we've also seen it from the other side, which is if you kind of know what the end goal is and you kind of begin, so you take trial early on and you kind of get that embedded and you understand what the end goal is, when you start going through those other courses, you're going to get a whole lot more from them because you're going to understand the end goal as to what you're trying to put together. So I can't really give a strong suggestion as to when you ought to take it. I mean, in a perfect world, ideally,
Take it twice.
you know, yeah, you're always going to, there's always going to be more to learn. And the thing about the KTI courses, I've taught a number of them. I've taught focus groups, I've taught rules, I've taught voir dire, and now currently I teach trial and closing argument. And the problem is that I've gone through most of the courses at least twice, and I am always getting new stuff. I mean, I go through it and my notes, I have taken the same notes, but they mean something completely different the second time through. And I guess, you know, that just boils down to more experience, more knowledge, learning more, and understanding how they fit. So I would say, you know, manage your expectations. If you're going to take it early on, understand you probably will not have a firm grasp on a lot of the stuff going on. But it will shape, you know, context is everything. If you know that end game, it's going to change the way you approach some of the other courses. But there will be some, you know, getting thrown into the deep end of the water. So I don't know that I can say there's a perfect time to take it, but take it twice, right? Take it early and then take it after, because you're just going to learn more and you're going to get better at these concepts.
Mm-hmm. Yeah, I think that's good advice. And it's hard to think about taking a course twice because it seems like you're going to, like, you know, doing the same thing 2 times, but it's, as we talked about with a couple of the other faculty, both with Toby and Carrie, you know, you got to get out there and put these things into practice. And once you have, then you see, okay, did I really understand that? I don't know. Let's go back and look at it again. And like you say, you may be taking some similar notes, but they mean something different because you're like, oh, I tried this, or I attempted this and it worked, or it didn't work, or I didn't understand it. And so taking it twice, I think is, you know, it's a hard thing to advise people to do, but if you are a fortunate enough person to do it twice, because that I can see how it can lay a foundation, but also be something that's really good for icing too.
Yeah. So one other thought I had, because, and like I said, it cuts both ways. The people who have gone through a lot of the courses and then take the trial course towards the end of their KTI journey, sometimes they feel like it's repetitive, and there's a lot of concepts that they've already learned and heard about in other courses. That's 100% true, because the purpose of the trial course is to understand and take basically all those pieces and show where they fit when you're structuring and when planning out your trial. So there is going to be a lot of review, but I say that guarded. I wouldn't call it a review, because what we're doing is we're taking those concepts that, yeah, absolutely, you've heard in the voir dire college or you've heard in the rules college, but we're going far deeper on it, and we have to. The reason why is because, again, if you are truly going to have these tools available to you so that you can start putting them in practice in your own trials, you need to have that understanding. Because if you don't know what the purpose is or why the tool matters or how to use it, then it's not going to work. And that's a big major focus of the trial course, is taking all these pieces and all these concepts that we've learned and learning how they all weave together into what Mr. Keenan calls the symphony. You know, that's the culminating moment of everything that we're doing, is so that we have a nice, cohesive, nice sounding symphony at the end of the day. And when you try these cases. So yeah, that's what I'd say.
And I kind of previewed this episode last week by telling people that it can be a somewhat confusing course, right? Because of this, what it's called trial. And so you think, well, maybe it's going to be the nuts and bolts of trial. But we actually have trial management that David Hoey is going to speak to us about in a few weeks in June. And that's a little bit more of a kind of a nuts and bolts class. But this Undergraduate Trial College really is about that philosophical, how are we using these pieces and why are we doing what we do? Which, yeah, can be a little bit of a brain teaser, but it's a good exercise. It's a necessary exercise.
Yeah. I mean, it's frustrating. I'll tell you right now, the amount of time that we spend, you know, game planning our trials and taking these concepts. So, and this kind of, you know, leads into a preview of the course. there's really kind of two days. It's a 2-day course, and there's kind of two different aspects that we're trying to teach. The first is just that strategy of the symphony, how these pieces all work together, so that you have this cohesive, strong message, a persuasive message that at the end of the day obviously results in verdicts. The other side and the other day is a lot of focus on the tools, the different tools that we have available at our disposal in a trial so that we can get that message across. And so that's kind of the way in my mind it breaks down, is that you have the strategy and how to game plan these things, what messages need to be accomplished at each phase of trial or with each witness. And then, of course, the other side is the tools, which we talk a lot about demonstrative evidence. Let me look at a couple things here. Demonstrative evidence, we talk about, the use of power words, visual rules. I mean, all these things that you've been learning and these tools, now it's time to put them into practice so that you can plan out your trial and make it as persuasive as possible. Put yourself in the best possible position to get the verdict that our clients deserve. So it is very good. It's a lot of material, and it comes at you fast because we've got to get it to you. That's the point, right? Is to make sure you've got these tools. So one thing I always tell everybody is that if they have questions, if there's follow-ups or they have disconnects, absolutely hit me up. I love game planning stuff. I love thinking things through. So, and that is where, a lot of it's been tough with the Zoom, but I think we're going back at some point, somewhat soon, for in-person. Doing these role plays and learning, it's tough to do that over Zoom. I like in-person a lot more for that. So, and that helps, practice those concepts. So you learn them, and then it's obviously putting them into practice in your own case and practicing them at the college. So, yeah.
Yeah, it's a lot of I hate to say higher level thinking about something, but or like a deeper level, as you say, we go into these concepts that you've learned, either if you're taking it early on that you will be learning, or if you're taking it towards the end that you've already heard about, but really talking about embedding them throughout the trial. And that's the part that takes a lot of, I don't know if anybody has taken a philosophy course ever. I took one during J term in college. Whoa, it is just wild. And it kind of feels like that at trial, because you're thinking about a concept in a lot of different ways. And then you're watching other people try to apply that concept to their case. And it's like, okay, I see, that is making sense. And then you're thinking, well, how does this apply to my case that I brought? And then possibly even another case that's back at the office that is similar to somebody else's. And it's in each of the undergraduate colleges, you get a roadmap or a template to get out there and do the thing that you're learning, whether it's depositions or voir dire or whatever. And this one is about the why. Like, why are we doing it? And what is the purpose of it? What are we trying to get out of it? So it's a little bit more ethereal and intangible. I move my spirit fingers because it's kind of like that. It's sparkly. I'd say it's a great college, though. It really is. But it's really going to force you to dig deeper there.
Yeah, I think, along that line, what you get out of it is what you're going to put into it. I will say this, when this course got revamped, and it was revamped about, like I said, about 4 years ago, it has completely changed the way that we approach trials and setting our trials up. It really does force you to think and figure out what evidence is good. One thing that I struggled with, well, I still do, but and I think this is probably true for all of us, and this is a constant theme throughout any KTI course, is we go out there and you do discovery, because that's what we're trained to do, and those are the nuts and bolts. We go get all this information, and we have all these details and all this evidence and all these facts. And, earlier on, and even now, in my practice now, I still struggle with this, but you have all this stuff. And the whole point of trial is to whittle it down so that you have your main key concepts that are going to, one, win you the case. But then the second part is you want to win big. So that is where to do that, it's tough. And this is why it takes so much time and so much thought, is that you really have to game plan everything. Every piece of evidence, every demonstrative, every witness you call, you always have to ask that question, what's my purpose here? What are they going to do? How are they advancing the ball forward? And so once you kind of get that picture and you know, all right, this is going to be what my order of proof looks like, right? This is how it works. I got all my parts hit. Now, this is where the tools that you learn in the trial course come in, because now you start to say, well, I can bring this up with this witness this way, or I can, present this way. And the key is it takes a lot of creativity. It takes a lot of time to think it through and creativity, because you don't want, we know the rule of three, right? Tell them what you're going to tell them, then tell them, and then tell them what you told them. That's the problem is if you do that the same way throughout the trial, it gets boring, right? Like they know, and it's repetitive and it's not new or fresh. So it's not developing and really kind of sinking into the jurors' minds. So that's what a big part of it is understanding these tools and the power of them so that you can then combine them and embed them into your trial. So
how have you seen this course change your trial practice or bring different elements of it to life, of your trials to life?
So, I just spent how many ever minutes saying that there's no template, but it does. There is a template in the sense that, we talk about there's 7 threads for trial. And so each of these threads, which are a lot of concepts you've already heard, foreseeability is one of them, safety rules is one of them, but there's 7 threads or kind of themes of trial. And the whole point is you want to be able to take that thread or that theme and put it in as quickly as you can with the jury. If you get voir dire, great. We teach you ways to embed it in voir dire, which obviously overlaps a little bit with voir dire college. But that's the whole thing is in voir dire college, you just learn how to embed it and talk about it. When you take trial and you combine those, you get the full picture, the bookend. You now know, oh, I see why I'm embedding that in voir dire, and then how I tap on it and carry that thread throughout the trial. So, sorry, I lost my train of thought. So we've got, you have these threads and you find out where you can put them in, and that's what the tools are for. And then you go through the entire roadmap of trial. For me, how that's changed the way we approach trials is I have a guidepost. I know that I need to get some of these 7 threads to start out very early and obviously carry throughout the entire trial and end. So it does provide the template as far as that goes, which is just, these are the themes or the threads that you need to be developing from the get-go, and then obviously carry them through all the way. That's about the extent of the template. After that, that's where you need to understand your case. You got to do the focus groups and understand what's important to them and why. And then it just becomes the creative task of taking the tools, the demonstrative visuals that we talk about in the trial course. We take all of that and you find creative ways that are impactful so you can present that to the jury in a non-boring, like I said, it's non-boring, persuasive way. And that's the challenge. That's the biggest, the biggest problem. So.
Absolutely. There are quite a few checklists, I think, aren't there, in the trial college that we get? And that's kind of become a theme throughout Edge in the past few years as Papa Don has been revamping colleges and, the openings and things like that, really talking about checklists. Will you share with us some overarching checklist concepts, what we can expect from checklists and how those are utilized and how you utilize them, that kind of stuff?
Yep, you bet. So one is a checklist that I don't think about anymore. I've got it right here. It's the trial brief checklist. So one thing is if you want to be able to, talk about deterrence or, whatever it may be, what the challenges are going to be. So we have a trial brief checklist, which is literally a checklist of things that you need to have a trial brief ready to go on. You need to know your state's law and have that brief ready to go that in the moment when the defense is objecting or they're trying to keep you from doing something or saying something, in that moment, you do the sidebar and we go up and you just hand that brief to the judge and say, Judge, I kind of anticipated that this is something that they might, object to. So I've already got a trial brief ready on it, which will hopefully, help the court make the decision. So you give them that in the moment. And when in that moment, you think about that concept, like think about that situation. If the judge is trying to make a decision on whether you get to say the word deterrence or whether you get to talk about a statistic or whatever it is, motive, foreseeability, there's a lot of different, trial briefs that we have prepped. In that moment, if they're just objecting and they're saying, well, we don't like it because we think of this, but then you hand the judge that trial brief, that gives the judge a whole lot of peace of mind. I mean, they may not even read it or really read it in depth, but if they're looking at it and say, well, you're saying this, our controlling precedent allows you to do this, that's just a fundamental to success, because then, it gives the judge confidence, you get to do what you want to do, and also, keeps you out of the scary waters of appeal land. So, so we have a whole list of areas where you need to have a trial brief ready to go. Probably the most, based on feedback, the most beneficial, we have a checklist for before and after witnesses and what you need to do with them. But the most beneficial that we've gotten feedback on is the expert checklist, which is there's 10 things that your expert needs to do. And I will tell you that checklist alone is pretty revolutionary. I've had to fire experts after we got this, and that again was about 3.5, 4 years ago. I came back and we started running through all of our cases and going through our experts, and we had some conversations with some of them, and I'll tell you, they were resistant and didn't want to do it. And so we said, well, hey, sorry, we'll catch you on the next one, but we won't.
Yeah, but not really.
I mean, if they're not gonna help us develop these concepts that we know, and obviously Mr. Keenan has spent an incredible amount of time focus grouping these things and researching them. So there's no question, we know the power of what is available and what's being taught. So if I don't have an expert that's willing to help me out with that and help develop those, I got to get rid of them. And we had to let 2 go. So that's a big one. That's a huge checklist that people will get, is the expert checklist as to what you need from them.
Yeah, that's huge. And it doesn't, just like with demonstratives, even if you have spent good money on an expert or on a demonstrative or whatever it may be, if that person is not going to do what you need them to do. And I'm just kicking myself. I love doing this podcast for the purpose of just remembering how badly I've done things recently. But I had, she was a treater, and we had a different philosophy in this case recently that I tried. But I had a meeting with her and I said, well, your role as the treating provider. And she said, hey, my role as the treating provider is what I say it is. And I was like, oh no. And I couldn't do anything. There's a lot I couldn't, I had to keep her on. But, it's not good, right? You don't want to have that disconnect with your person who's supposed to be helping you and carrying part of the weight of your case. So, going back to these checklists, it's imperative. And I know when we go through all these edge things, there's a lot of stuff to think about. There's a lot of things to remember. And, so when we do go out and do trials, sometimes I forget to go back and look at things and make sure I've gotten them ready. But it's so important, because if you don't do it right, then you're going to fall on your face and get a verdict you didn't want. So that's crucial. And then with the trial briefs, in trial college, we don't give you the briefs, right? We tell you, I guess, what topics are, then you've got to go out there and do that research so that you know it. And that's not to say the judge is going to follow it. They may look at it and be like, I don't care if defense doesn't have a supporting case. I think it's fair to go that way. So that's, it's not a promise or a guarantee that you're going to always get the right decision on your side, but it's going to prepare you. You're going to have the best argument. And if you do have to get into scary appeal land, you'll be ready to go there because you've done the work ahead of time. So these checklists are super important. Take it from me. Kind of dropped the ball there on them just recently. Got to do it. And you really need to force it, stick to it.
Yeah, there's a couple things that are, like I said, I call them fundamentals. They're fundamentals in the trial course that we talk about that, as I've like kind of thought a lot about the material in the trial course, but just trials in general and what KTI does and what the EDGE concepts do, they give you that preparation. It's a lot of work, and that's what I think people who do have kind of criticisms of not just the trial course, but KTI courses in general. Honestly, the common thread that I see is that they are kind of looking for the easy way out, kind of looking for something that's quick and easy and kind of a gimmick. And this is anything but. It's a lot. It takes a lot of work, takes a lot of focus. It does, get better with time. You get faster at some of these things, but the power and what, one thing I love about KTI and what Mr. Keenan has put together is he's not giving us templates. I mean, there's templates in certain things to kind of help, but at the end of the day, what he's trying to develop is trial lawyers. And that is the key. It's learning to think about a case differently, and that also goes back to your question earlier, how it's changed, the way we prep for trials. It's completely changed it. We have those elements and those threads kind of on our own, like not template, but kind of a guide or an outline. And then for the case, we go and we have to fill that out. And the reality is, and this is perfectly normal, sometimes you don't have a certain thread or your evidence isn't super great. And so this allows you to look at different avenues and then, like I said, game plan. But you can't do that unless you have that deeper understanding. And that's what we're trying to get. And that goes to, again, what Mr. Keenan is trying to do. He doesn't want this to just be, hey, try this and then you got to keep coming back, right? You got to keep coming back every time you have a case, and then we'll workshop that case. I see that with a lot of attorneys who do the referral type thing, where they don't teach their secret sauce, so to speak. They just keep that because that makes them valuable, right? You have to keep going back to them. And that's one thing I love about what Mr. Keenan's put together here is, he's trying to teach us and get that deeper understanding of these things, so that we can do it on our own and we don't have to keep coming back and be dependent on others. So anyway, I don't know if that ties in at all, but.
Yeah, absolutely. What should we expect to need to bring to this course if we're going to take it? And then what do we expect to get out of it when we're done?
So you're going to need your opening statement for sure. But that's because, if you've taken openings and that contains our order of proof. But yeah, what you're going to need that because you're going to need, in order to dive that deep on a case, you're going to need to have a case that is fairly well developed at that point. You can't, you need to know what your evidence is. You need to know, what your strong points are, because if you don't have that stuff, you're going to show up, you're going to be learning these concepts, and you're not going to be able to relate it to the case that you brought. So you're going to want a case that you've been working on, what the evidence is, what cards you're holding, so to speak, and then you can start to see how the pieces fit in and how, while you're there, and this is why I've repeated a lot of the KTI courses, because I always go with a different case. And one thing that I started to do is I would take my crappiest case, the case that was just hard as could be, because I thought, well, if we can figure out how to make this case a winner, then these other ones will be cake. And there's a lot of truth to that. It was a lot more work to try and figure those out and crack the code on them, but doing that repeat and learning, bringing different cases that are fairly well developed so that you can apply these concepts, that's going to be important. You're going to get far more out of it for that. As far as what you're going to get out of it, like I said, you're going to get a whole list of ideas, a whole list of demonstrative evidence that you can use and develop to, hit certain points or develop threads in your case. You're going to get the 7 threads and understand what those themes are, which give your case power. You're going to also get, obviously, the checklist. Those are more kind of the nuts and bolts, I call it, where, your trial brief checklist, these types of things. But then I think, and this can't be understated, you're going to get confidence. I think you're going to take away and have a far better understanding of what the goals are for trial. One thing, I'll just tell you this, an example for me. I would want to just get everything out at once and just try and get all this information. What I mean by that, I'm not explaining this well at all. I'll get there, don't worry. I had the tendency, and I still do, and this has helped me kind of calm down a little bit, but it's I just want to shotgun the case, which is I just want all my evidence out there at once. And I wouldn't really think how it's flowing or what if it is flowing. That never entered my head until taking the trial course and starting to understand there is that symphony, there is that flow. So when you start mapping out your trial, and this is one of the tools that you'll get is, we map it out. There's a kind of a form that you can use for all the threads and all the elements that you want to hit in a trial. You have that, and then you have a list of all the witnesses or the evidence. So the witnesses or the documents or whatever it may be that's going to establish those. So if you have the safety rules, for instance, if one of your concepts is safety rules, then you can go through and map out this document gives me that, or this witness will give me that. And you have all these places. So by the end of it, you may have 11, 12 different either documents or people that can talk about the safety rules. But you don't talk about the safety rules with all 11 or 12 of them. That's where you map it out. And then you start to say, who's going to be the best? Who's going to be my best witness, or what's my best evidence to establish this concept? And once you start mapping it out that way, it really becomes, it's fun, but it's also frustrating because you say, all right, we got to keep this thread alive, right? We don't want to just talk about the rules in the opening and then have my first witness talk about the rules, and then I don't talk about it again until closing arguments. You have to keep reminding them, right? That's the art to it, is you have to remind them throughout the trial, but you can't do it in a way where it gets boring to them. And it's yeah, we've heard this. You've talked about safety rules 100 times. Because if it does become repetitive in that way, they tune out. So that's where, one of the big takeaways you'll get is, first off, the tool, kind of the grid, if you will, of how to map out and outline the trial. But then it's that confidence of understanding, okay, even though I could have 11 witnesses or 11 people talk about safety rules, I don't need that, right? I just need, a certain number, and it's got to be spread out through trial so that it's a constant theme that they're hearing about. But I don't have to, just because they can say it doesn't mean that they should, if that makes sense. So you really gain that confidence to say, all right, we're not going to just hit on this theme because we can. We're going to do it strategically and smart. So I think that's a big point. A big takeaway is the confidence to do that. And then also with that, I'll say this, is forcing, the students to really understand these concepts and dive deep on them. It's fun. And this I love is when we're kind of game planning the trial, me and my paralegal, and we're talking about it. And it's once we're addressing a specific witness, yes, there are a lot of things that we could talk to that witness about or draw out. But answering that one simple question, what is the purpose of this witness? What goals do I need to accomplish with this person? Allows you to limit so that you're not having lengthy, long testimonies. Everything is to the point, and it's clear and it's concise. And then it's that understanding of having that patience to say, I don't have to shotgun this. I don't have to get all of this answered and all this information out on my day one of trial. You can kind of sit back and take a breath and say, okay, no, we don't need to do that on day one, day two, or day three. We just need to set up for the future, if that makes sense. It's tough to talk about that without a specific example, But that's why it's important that you bring a developed case so that we can start to dive into those nuances and those details.
Yeah, exactly. And there's a fair amount, I think it's on, well, I guess it just depends on how the course goes, either the end of day one or early day two, where we go through people's cases. And you were talking about role playing earlier, but really just diving into how some of this stuff can apply to your case. And that's an exercise that, you know, some people get frustrated because they think trial's going to be one thing and it's another and blah, blah, blah. But that's one piece where everybody can agree, I got something out of it, because maybe I was confused about why you were telling me this checklist or why you were going back into this concept I already know about. But going through and really putting the concepts into people's cases, you see where the rubber meets the road. And we provide the spreadsheet, right, in trial, for you to lay out your witnesses and what things they can talk about and what testimony they can provide. And it's a bunch of little X's and notes and things like that, so you can really see it and how your case is developing, and then move things around and make it as effective as possible. So really getting in there and doing your case is a big part of then putting it into practice and making sure all of your cases have these threads and everything else that go through them.
Yep. Yeah, one other, I guess, big takeaway for me that I would expect students to get as well is there's when you think about your purposes, like, and I touched on this just a little bit earlier, you have the purpose of winning, right? You got to have that baseline to win the case, but then there's a separate there's a separate trial almost going on where you're going to win it big. And so there's a big difference between kind of providing those, the safety rules and the clear violation of those safety rules, which that ought to win you the case, right? If you've got that if you can establish that. But winning the case, yes, that we want that, but we also want to win big. And so we talk a lot about that in the trial course as well, it's the emotional, right? The emotional stool and the emotional buttons that are going to win that case big for you. And that is why it's so important to start to game plan and roadmap your trial so that you are priming them for that. They can't, one thing I made the mistake quite a few times early on in my career was I was like, oh, I'm going to save this best piece of evidence for the end. I'm going to bring this up, or I'm going to connect these dots in the closing. And, well, that was wrong. And Mr. Keenan let me know, no, if you have something powerful, closing is not the time to start throwing new stuff in there. Closing is where you have already developed these threads, and you've developed them again as early as possible in voir dire if possible. If not, then in your opening, and then you've developed them all through trial. And then closing is simply where you just wrap it all together and get that jury empowered to do what's right. So that's a big takeaway, is to understand what the difference is between winning, just winning the case, versus winning big, which is what we all want to do. So.
Yep. Yeah, and sometimes we think that if we've won the case, right, if we've met the burden, if we've got the evidence out there, then that's enough. And it isn't quite, because really what you have is getting there, meeting your burden, getting the evidence out, and then there's this big space here or a disconnect really between getting there logically and asking for a large number, and having the jury try to figure out, wait a minute, how am I getting from, yeah, I saw your evidence and I see what you're asking for, but I don't know how those two things connect. And the trial course will assist with that. I mean, that's, I think, a lifelong learning process as well, or a career-long learning process, right? How to get from meeting your burden, getting your evidence out, and getting the jury to buy into that ask. But, if you're able to establish the thread and, connect the whole trial together, you've got a better shot at it than if you're just saying, here's my evidence, now give me bunches of money, right?
Right. The way we think about it here in our office is, you've got this, you have kind of that logic where you have to have that to win, right? To get them over the hump and say, okay, yeah, they were negligent, right? They broke the safety rules. But what you've got to do and where the power comes in is when you can give them the moral high ground. When not only do they say, yeah, they were negligent, but then they feel good about what they're doing. And they say, you know what? Yeah, like this is a problem. This is, I'm not going to let this slide. And they have that moral high ground, because I'm sure if you've done focus groups, at all, you will see when you let them deliberate, when you've given them the moral high ground, or when they have the moral high ground and when they don't. And when they don't, it's like, well, yeah, they were negligent. But then what you get is you get a verdict that's basically medical bills, right? It's medical bills and maybe a couple thousand on top of that for pain and suffering. It's nothing great, versus a situation where they understand. And like I said, we noticed the biggest difference when we started embedding these concepts early in the trial, because it allows them to kind of marinate and be on their mind. So then when you get to the closing and you get to the point where you're going to ask them, and this feeds right into the closing college, which I also teach, which is great because you see how it all comes together for that closing ask. But if you have not laid that foundation early on, it's going to be foreign. It's going to not feel right for you as the trial lawyer. Like, it's going to be kind of like, oh, I'm asking for this, but I don't really have my reasons well developed, right? Versus when you have gotten those concepts embedded early on, you've talked about them. By the time you get to closing, it's just simply natural. It's just natural and it flows, where you just say, look, this is why, let me tell you why I think this amount of money is appropriate. Here are my reasons. And you go through, and it's not the first time they're hearing them, right? They've been developed all the way through, and those tie directly into those 7 threads.
Mm-hmm. Yep. And you want to keep that. I mean, I love how you said moral high ground, because that's how people make decisions, right? And that's really going to tip people from just the medical bills and a couple $1,000s for pain and suffering to your larger verdicts. And really keep your eye on that ball, because if your case throughout trial, trial is so chaotic, right? Because the judge is making rulings, and then this is happening and that is happening, and your witness isn't saying what you thought they were going to say. And it's all, keep your eye on that moral high ground ball. If you lose it, to be honest, it's a point where you need to really think about whether it's going to harm or hurt your client to continue on. I mean, there's all kinds of places that Papa Don talks about opportunities for settlement before trial, but also during trial. And maybe if you've completely lost that moral high ground, maybe you feel like, oh, geez, I don't know, it was something I did, or was it a ruling? I don't know, I've lost it. Maybe it's an opportunity to consider resolving it, right? Or maybe you don't get to that ask because you don't want to piss off that jury or leave them with that huge disconnect where they hammer you with something that you're shocked by. So, when there's bad rulings and things like that, you got to woodpecker around them. But ultimately, your eye needs to be on giving the jury something that they can feel good about giving a good verdict for. If they don't have that, and if you pay close attention to it, you'll see it. You'll see it in their body language and in their facial expressions if they don't have it. And I don't know, I have been there, and it's a scary place to be. And I don't think I have the perfect solution to it, but it is this concept of, weaving your threads throughout is so integral and so important that if you don't have it, it's a place where you might think about, whoa, what am I doing here? And what am I going to try to do to get a good result for my client?
Yeah, and that's why another way it's transformed. I've been talking a lot about how, the trial course will transform the way you plan your trials, but you bring up an excellent point. And that is when you take this and you ought to be implementing this stuff early on, right? When we start game planning, we have a document in our office that's the trial threads. I already talked about this, but the point is if we are developing those, and sometimes when we file a case and we haven't gotten into discovery yet, we fill that out anyway. We go with our gut reaction. What do we think is going on? Now, I've had it happen where the evidence has come out, and quite frankly, those threads were not getting developed. It just wasn't there. We could not establish the thread that we thought we were going to be able to, and we didn't have the evidence. So that was a good indicator for us and clued us in that, we need to put this on more of a settlement track, right? We need to position this like we are going to go trial full bore, But ultimately, we gotta, and this goes obviously to the mediation college, but we got to get this to a mediation, and we got to have control and make sure that we get it resolved, because we don't have that moral high ground. We don't have that good reason, right? That strong, compelling reason that jurors will say, yeah, even if they're on the fence. I mean, you'd love to have them just 100% on your side, where it's like, yep, you are doing God's work. Go forth and do it. And here's a huge verdict to keep doing it. That'd be great. But the reality is you're going to have those jurors that are on the fence, that they don't know, and they maybe feel bad for the defendant, or they're wondering how they're going to pay for it, like all of that. So you got to have these strong, compelling reasons for them to jump off that fence and say, you know what? Yeah, push comes to shove, we got to make some changes here. We got to make sure that this company or this defendant changes. So having those threads developed, which is, develops that moral high ground, you learn early on. If you apply this and start game planning it early on, you'll know, rather than the week before trial, that you don't have it, which is not a good feeling. I've been there. The other thing is, the preparation that goes into this, meaning the preparation that goes into trial, and all these tools and all these things that you learn in the trial course. I'm going to fall on my sword and tell about a trial I had where I had not. This was before. I'd taken a lot of the KTI courses, but I hadn't taken them all, and I wasn't teaching or anything. And anyway, I fell into that exact trap. I did not have this thing prepared. Obviously, I didn't even have the threads. I didn't even know order of proof, this kind of stuff. But I got to the trial, and I was facing a defense lawyer who'd been practicing for about 3 decades. He was very good, one of the top guys in Utah. And what he did is he objected to everything I did. I tried to call my client to the stand, and he objected. And we had to have a sidebar, and I had to explain why I could call my client. I mean, it was the most insane thing. But what he did, and what I realized, is he was throwing punches left and right, and I was not prepared for him. And it put me on my heels, so to speak. And I never was able to regain kind of not just my confidence, but the confidence of the jury. They saw who was in control. They knew who was in control, and they gave my client a verdict that was, medical bills and a little bit on top of that. It wasn't very good. So that is the other thing I think you'll get from the trial courses. That preparation gives you that confidence so that you're ready for it. And when you get that defense lawyer who is going to object to everything or cause you problems and throw up roadblocks, you've got an answer and you're ready for it. So I think that's an important takeaway as well.
Mm-hmm. That is. And, maintaining your cool and maintaining control is so important because of the perception of the jury. And Papa Don talks a lot about meeting the jury where they are. And we've talked a lot throughout this podcast series this year about meeting the jury where they are, giving them what they expect. And, we're taught in Edge not to do a lot of objecting. And we lay the foundation for that early on in voir dire. There's a way of doing that you'll learn if you go to the voir dire college. But I've had a lot of juries after the fact say, the defense objected all the time. And I love that. That meant that they knew what they were doing. And you just looked like you had no idea what was going on because the judge kept sustaining their objections. And I'm like, that I think that's something I still work on, because I still, judges don't make the best rulings in the heat of the moment. And sometimes they fall into the exact same pattern that the jury is in. Well, if defense is objecting, there must be something wrong. And so they sustain things that they probably shouldn't. And you just have to be careful. And a lot of these colleges will give you the tools, especially with trial and having the foundation, the confidence to know what you're doing and whether it matters or not, if that objection is sustained, how to handle that and still come out on top as the person who's in control, who knows what you're doing. If the judge says sustained 17 times, you still are the person who knows the law better, or has at least have given the jury that moral high ground to be on your side. It's tough because that's juror perception is so much of what we deal with, right? It's another defendant in the room. It's really another defendant. It's just how they perceive you, and they're judging you. They don't care about the defense lawyer so much. You've got to turn those tables. You've got to work hard on that.
Yeah, that touches on another concept we talk about in, it's actually one of the threads, so spoiler alert, but it's the POV, the point of view. You got to know what the point of view, and see, when I first, in KTI, when I first heard a point of view, my thoughts were, okay, it's the juror's point of view. That's what we are concerned about. That's true. That is paramount. Obviously, we want to know, we need to know what the jurors think about things or what their POV is on different things. But what we do in the trial course is we extend that concept of POV, and we start asking, what is the POV of every witness, right? Each witness, what's their probable POV? Same thing with our witnesses, our client, experts. What's the judge's POV? Right? Like, these are all things that we dive into. And the purpose is that if you are looking at something through their lens, you're going to be able to speak their language much better. And it's going to be far more persuasive. But the mistake I had is the extent of my analysis of POV was, oh, what's the jury think and what's the jury want? The reality is, in trial, that's not going to cut it, because you have to know what, the judge's POV is, the witnesses. If you want to elicit certain testimony or get the defense witness to take a position that you need them to, you got to know what their POV is, and you got to think about that, and then plan your whether it be your examination or whether it be having the trial brief. Like I said, like, the judge's POV is. The biggest struggle I've had in my practice is judges who see what I'm doing, have looked at me as being young, and that I have no idea what I'm doing. Mm-hmm. And what I'm doing is I'm simply taking what I've learned in KTI, and I'm trying to try the case that way. Yeah. It is a foreign concept here in Utah. The vast majority of my judges have never heard a lot of this stuff about talking about foreseeability and deterrence. Good luck. I still fight that battle to this day. Everyone thinks that deterrence is punishment. It's punitive damages. No, it's not. So I have to have a brief on that. But the problem and the biggest challenge I had was I'm young. I've been practicing, I guess, 7 years now. And so, but early on, if you've only been practicing a year or 2, 3 years, and you're trying to do stuff that these judges have never seen, they're just going to say you're wrong because you're young and you don't know what you're doing. And so that's been a big time barrier, where once we've got these trial briefs put into place, and not only that, it's not just the trial, like starting with voir dire, our pretrial conferences, our, getting ready, talking about jury instructions and going through pretrial objections with the judge. Those are also opportunities to start priming the judge based on the judge's POV, so that you can get permission, or you can have a higher success rate of getting the evidence that you want in, or the argument, or whatever it may be. So it's challenging for sure. It is. Trials are not for, I don't know, what do they call it? Weak-hearted or something?
Faint of heart.
Faint of heart. Thank you. There you go.
Don't be faint of heart if you're going to try cases. You have to be strong. You have to, I have cried in trial because I simply am so upset that I don't know what else to do. Things just, and not even, I think I talked with Toby last week. I had a juror tell me in my last trial, I got emotional one time. I was so proud of myself. I didn't get emotional the whole time of trial. Last 1 minute of my closing argument, because it was a really big deal for my client, I got emotional. Juror afterwards, they gave me an okay verdict, and the guy was like, that was the most unprofessional thing I've ever seen, you crying during your closing. So it's like you have to be able to stand up to that stuff, whether it's coming from the judge or it's coming from defense counsel. And the biggest thing that doing this trial college does is give you the confidence to know at least you're doing the right thing, right? You're at least doing it correctly. And I get frustrated with lawyers who've gone before, right? Like, speaking of being a younger lawyer, lawyers who've gone before and not done us any service in this. They've not adhered to black letter law. I mean, when I give a judge a brief and it's got 16 cases that say I can use the word deterrence, but then defense says, but that's not fair, and the judge sides with defense, that's not on me. That's on the dozens and dozens of lawyers who've gone before me who've been like, yeah, you're right, that's not fair. I won't say it. Don't worry about it. You know, there has been a system, you know, leading up to where we are now that we're trying to dismantle, and it's very, very hard. It's very hard. All right,
Yeah.
we have a question. Okay. Peter Gorski says, what trial or information management software do you or others use to keep all of the information organized so you don't forget documents, testimony, what you'll present, and through which witnesses? This is a really good question. Yeah, go ahead, Blake.
Yeah. So I don't know that the particular software is important. I think what's important is to have that grid. You know, the trial map, that's what we call it, is the trial map, where, you know, it allows us to game plan the trial and say what threads or what themes do we need to establish. And then you just have that entire grid. And we were using an Excel sheet, but now we just use a Word doc, and we'll just go in and type everything out. But we do it very detailed. I mean, this thing's incredible when we are ready for trial, because it not only has all of our witnesses, but then it also has any of the documents and exhibits that we may need to use or that we are planning on using to establish that theme, whether it be the rules, whether it be foreseeability, whatever it is, whatever we're trying to do. And it's very, very detailed, and it's in the front of our binder, because what it is if as we're getting ready, we know, and it's got all of our exhibits that we plan on using, or documents, or whatever it is, and it's got them listed and referenced so that we know exactly where they are. And so it takes a lot of time to craft this up, the trial map. But once you've got it on a simple, like I said, use Microsoft Word or Excel, whatever works for you. The key is, and this is where the benefit comes in, it's the process of going through and organizing it that way on that one sheet. That process takes hours and hours and hours. But what happens is, by the time you're ready, when you're ready to try that case, it's already up on your mind anyway. Like, you're ready to go. So you can recall it quickly. You know what you need. And then if you need to find it, we just flip to the top of the binder and say, okay, where was that training doc at? Oh, it's right there. It's DEF 78. Okay. And then my paralegals got it for me, and we're flying. So that is the way that we organize it. That trial map has all of our witnesses, every witness that we expect to call, also defense witnesses, obviously, because they're going to call theirs. It has everybody on there. And then the key is to whittle it down and whittle it away so that you know these are the exact hits. These are the exact questions and hits I need to establish with this witness. And here's how I'm going to do it. Or if we've come up with an amazing demonstrative, which is like timelines, right? Timelines are big. They're super helpful. They're very, very persuasive. So then we say, okay, we'll start with the end. Sorry, we're close to out of time, but I love this stuff. So, but you get this timeline, and we build the end timeline, and we have this thing sitting there. And then what we do is we take each piece of that timeline and we say, how do we get this? Where are we going to prove this so we can put this timeline in? And at the end of trial, we can send this back with the jury, and they have this bona fide timeline that's clear and concise. And so you go through each flag and say, we're going to establish this with this witness and this document, right? Or these documents. So hopefully I'm answering your question. Those are some ways that we organize and structure our trials so that we have those roadmaps ready for us.
Mm-hmm. Yeah, I don't know that there's a software out there, and my husband's a software engineer, and he said it's because they hate lawyers so much, they aren't going to help us do anything. So, but I think it's got to be something that you kind of do as you learn and go through all of these things. And to be honest, I haven't gotten quite the system that Blake has down yet, but a master checklist is one option, right? Of saying, what do you need to do through each point of pretrial and trial, and then branch that out into what college maybe applies to each one, and then what you learn from those colleges. And you can do those in, just files in your PC, or I don't know if you use a Mac, what the files are called there, but you can put all of that stuff there, or you can put them into binders. And I know Papa Don is a really big fan of binders. Blake, do you have one there you're going to show?
Yep, I do. So this is directly from Mr. Keenan, and you learn about trial binders in the trial course. So this is an example. I don't know if you can even read it or not. But what we do, this particular binder, it's our issues, meaning what are the defenses? What do we think the defense is going to bring up? And you probably can't even see it. But anyway, I have the title of what the main issue is. And then underneath it is what the argument is going to be from the defense and what they're going to use to support that, generally their expert testimony. And then the next pages are our responses to it with citations to the exact documents we will use. So this is one way we make binders for any defense strengths, right? Any defense strengths, any issues that we think the defense is potentially going to lower our verdict or win the case on. Do the same thing with our main points. So those threads, we have those, whichever ones we are going to take and develop during trial, we have a binder that is dedicated to that thread so that we know where all of it is. And that's, having that organized is very important because, again, just from a trial strategy standpoint, half of winning the battle is jury perception. If we look sharp, if we look prepared, if we look like we have everything ready to go and we're not wasting their time, they will naturally, their confidence in us will naturally develop. And then by the end, right, again, it's just natural. Like when you're asking them for the verdict, it's almost like this feeling of like, well, yeah, you were sharp, you were on it, you brought me everything I wanted, and you answered all my questions. I'm going to give you what you want. Mm-hmm. So hopefully that helps.
Yeah, definitely. And I think to the point of you're looking sharp, always deliver what you say you're going to deliver. And Papa Don is huge on this, whether it's pretrial, also never say something that you're not going to do, and always do what you say you're going to do. And that can quickly kick the jury off of your side. If you say something's going to be proved and it isn't, that skepticism is so dangerous. We do have one more question that I'm going to take before we run out, because it's also a good one. Kenneth Bland asks, what does the college teach about whether to file trial briefs, for example, deterrence and forbearance, beforehand, or hold them until objection is made?
Good question. This is where you got to kind of do some research on your judge. You got to know how the judge is going to make those decisions, or if they've ruled on the issue in the past. But generally speaking, the general rule is, put this stuff out there early, right? If you have this stuff and you're just waiting for the defense to bring something up, generally speaking, the judge is not going to like that much, because they're being put on the spot. If they have to make a decision in the moment, yes, you can give them the brief, and yes, that can help. But again, if it's a concept, or if it's something that they haven't really dealt with and it's new, even if you give them a brief, you run a significant risk that they're just going to say, yeah, well, you know what? I'm not going to get overturned, right? I'm not going to get reversed by keeping this out, because I've never had someone try and bring it up in the last 30 trials I presided. So that's the danger. And so the general rule on that is get it to them early. Let them know. Give the judge and say that, just so you know, I'm going to talk about foreseeability. I'm going to talk about deterrence. These are concepts that are supported in our case law, and here's a trial brief on it. And, I've done that. I've done both. And I've had both work, but I've also had both kind of go up in smoke. So, but generally what I see, if I file the briefs early, or, put them in front of the judge early, they don't make a ruling on it. They just say, well, okay, I've taken this under advisement, and we'll just see. If it becomes something at trial, then we can address it then. I'm okay with that because, like I said, I've given them a brief where generally the defense hasn't, and so when it does come out at trial, they've had time to think about it, and they're not making, not to get to the biophysics or whatever behind it, but they're not making that decision with cortisol running through their veins. Hopefully they've had time to think about it, and they say, yeah, no, and then let you do what you want. So, but I've had it go both ways.
Yeah, it's a hard one. It's a hard one to say that there's a hard and fast rule. It is discussed during the trial college, and we do talk about that concept and whether it might be a good idea to do it early on or have it, boom, here it is. And I think a lot of it has to do with your judge's experience. Like overall, if you have a judge who has had a lot of civil law experience, they're going to be more likely to be able to digest a brief given to them in the spur of the moment than a newer judge or I'll say newer because age has nothing really to do with it, whether they've been a judge for a while or not. But because it's all about a confidence thing, right? And Blake talked about POV earlier and what that means for a judge and where, playing when you file your brief and what that does to them and giving them the confidence they need to rule in your favor. And one thing that I learned recently was, don't be shy about trying to tip your judge off to the complexity of your case ahead of time. And some issues like early on, right? Even before motions in limine, right at the beginning of trial, early on, because a lot of judges will take for granted a simple car crash case or a civil case because no one's facing the death penalty or nobody is, has a sister who was murdered or something like that. And so it doesn't seem like a big deal to them. And then when they get into it, they're like, oh gosh, your case is a lot more complex than I thought. Don't be shy about bringing that up early on. And that goes hand in hand with when you file your briefing and that sort of thing. Give the judge that confidence and give them a heads up to the extent that you can. And certainly that's something that we talk about in trial.
Yeah. Sorry, one thing I want to add on that is, and I'll be quick, but also think about that the judge's POV and almost in a way, when you're arguing motions, whether they're motions in limine or whatever they may be, summary judgment is where I really hit on it as hard as I can. When the defense brings summary judgment motions, I always ask myself, what do I need to get the judge? What do I need to show the judge so that I have the moral high ground? So with the judge, so that the judge looks at it and goes, you know what, this was wrong. This wasn't good. Obviously, they're not going to say that. Mm-hmm. That's what I want them thinking in their mind is like, yeah, this is pretty shitty. Like, I can't believe the defense did this or the defendant did this. And because then that increases the chances that they're going to go your way. And so I've had a couple times where, in the summary judgment motion, one time specifically, the judge asked the defense, he said, so let me see if I understand this correctly. And it was a motion in limine. They were trying to get rid of all this medical treatment. He said, let me see if I understand this. You guys can have a defective pipe that leaked carbon monoxide throughout the hotel. You can hospitalize these people, cause traumatic brain injury, and then you want me to exclude the treatment that they've gotten? And when he said it and asked the question just like that, I said, I think I accomplished my goal. I think he's on our side here. We should get some good rulings here. And we did. So, just keep that in mind. What do you need to prime your judge on?
Yep. Yeah, that's true. And that also goes into researching your judge too. What issues do they care about? What, life experiences do they have? And some judges have more online than others, but, I had a similar situation where a judge got very upset at a medical malpractice defendant. She's like, wait a minute. Your doctor knew, your hospital knew that your doctor had this problem before, the exact same problem. And it was a very, very difficult corporate negligence in Washington. It's a very difficult thing to get any judge on board with. But getting her even to be like, wait a minute, you knew about this. And then you let it happen again. You could see her wanting to manipulate the law that she was aware of in our favor because of that moral high ground. That's a really excellent point.
Yep.
All right. Thank you so much, Blake. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you like today's episode, please click that thumbs up and like this video to feed that YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have Matt Lathrop, who will be speaking to us about the undergraduate voir dire college. Voir dire is one of the earliest places you can start doing what we just talked about today in embedding threads of trial. Selecting the right jury can make or break our cases, and knowing how to get a group of people engaged and ready to fight for your client is crucial. So make sure to join us next week to hear about how the undergraduate voir dire college can help you choose the best jury for your case. Matt practices personal injury law in Nebraska as well as being KTI faculty. So I look forward to hearing about the voir dire course from Matt next week, along with all of you. Have a wonderful weekend, and I'll see you next time.